So, good afternoon, class. We are now on our last leg of our discussion on the mitigating circumstances. So, today, however, we still have to review some of the mitigating circumstances that we have already discussed. So, I hope that you will not forget them, in as much as I hope that you will also not forget our justifying and exempting circumstances because what they have a relation to our mitigating circumstances. So as a review, the following are mitigating circumstances. Number one, those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. So it means that some of the requisites to justify or to exempt from criminal liability are missing. So we have incomplete self-defense, okay? So incomplete defense of relatives, incomplete defense of strangers, or all other requisites to justify or exempt the crime are not complete. Okay, so that is number one. Number two, that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. So, going back to our juvenile justice system, the age of criminality or criminal responsibility has already been raised. No, na instead 9 years old, we now have those who are below 15 years old. So, those persons who are above 15 years old but below 18 years old may still incur criminal liability if they have acted with discernment. So in such cases, even if they acted with discernment during the commission of the act or omission which constitutes a crime, they can still what raise minority as a mitigating circumstance. Okay, even if there was discernment on their part during the commission of the crime. Number three, that the offender had no intention to commit so grave a wrong as that committed. So remember our discussion before of a case wherein the person, his intention was actually just to inflict physical injuries, but he did not know, the accused here did not know that the victim actually was suffering from physical conditions that aggravated the the result of the crime. So instead of just merely inflicting physical injuries, the victim here died. But at the end of the day, the intention of the offender was not to kill, but only to what? To inflict physical injury. So if that is the case, the accused now will be what? Will be entitled to one mitigating circumstances for having no intention to commit so grave a wrong. Okay? Number four, that sufficient provocation or threat on the part of the offended party immediately preceded the act. So this is also an incomplete self-defense. So going back to our self-defense, what? That there be unlawful aggression on the part of the person defending, on the part of the offended person or the victim, what? And reasonable necessity or means or necessity of the means employed, and lack of sufficient provocation on the part of the person defending himself. So here, no, there is sufficient provocation on the part of the person, um or on the part of the offended party immediately preceding the act. Okay? Number five, that the act was committed in the immediate vindication of a grave offense to one committing the felony against his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity within the same degree. So we've already discussed this. So if there was a grave offense committed against 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 the spouse, the ascendants, the descendants, the legitimate or natural adopted brothers or sisters or relatives by affinity within the same degree, if the accused acted as retaliatory in retaliation, no, perform the retaliatory act against the victim because the victim committed a grave offense against his relatives, then that will not exempt him from criminal liability. That will not justify the criminal liability, but that can actually mitigate mitigate the liability of the person, which means, or the accused here, which means it can actually reduce, no, it can reduce the penalty imposable to the accused. Okay, it will not exempt him from the mitigating circumstances cannot exempt or justify the crime, which means the accused here will still be held responsible for the crime. He may still suffer the penalties for the crime. It's just that the penalty is reduced. Okay, for every one mitigating circumstance, the degree of penalty is reduced by one. No, so if number one is present, you reduce the penalty by 1 degree. If another one is present, you reduce the penalty by another degree. But we will discuss that as we go along to our discussions and our penalties. Now, for the meantime, let's focus on the mitigating circumstances. It mitigates the crime. It means that it reduces the liability or reduces the imposable penalty of the person who may be found guilty for a crime. Okay, so we've already discussed the first five. Now we move on to the 6th to 10th mitigating circumstances. Number 6, that of having acted upon an impulse so powerful as to naturally to have produced passion or obfuscation. Number 7, paragraph 7, that the offender had voluntarily surrendered himself, no, to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8, that the offender is deaf and dumb, blind, or otherwise suffering some physical defect which thus restricts his means of action, defense, or communication with his fellow beings. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of consciousness of his acts. And number 10, and finally, any other circumstances of similar nature and analogous to those above mentioned. Okay, so we will discuss all of these additional mitigating circumstances. We've already discussed paragraph 1 to 5. Now we will focus on paragraph 6 to 10. Okay, so paragraph 6, that of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. So, to have this as a mitigating circumstance, the following requisites must be present. Number 1, the accused acted upon an impulse. Okay, so it was impulsive upon him. Number 2, the impulse must be so powerful that it naturally produced passion or obfuscation in him. Okay? So he acted in impulse. No? He did not intend, he did not plan for things to happen. He was just acting as an immediate response, no, to a certain situation which produced passion or obfuscation for him. For example, so the crime committed by the accused must be provoked. No, there should have been a prior unjust or improper act of the injured party. So again here, the person raising the defense or the mitigating circumstance is the accused for a crime. So there is a case against him. But then, there is another person who provoked him, which is the victim. So, ang victim provoke anay hiya by doing unjust or improper acts. Okay? So, ang victim here, so there was the accused, no? So he committed a crime. So let's say he killed someone. The person he killed is the victim. That victim actually performed unjust or improper acts against the accused. So may dahiyagin buhat nga diri as siya actually what adi nga aton accused niya na perform the acts na which now tantamounts to a crime or felony. So what is the rationale behind this? Kay ano, why? Why is the government, why is our laws allowing this as a mitigating circumstance? Why is the government allowing mitigating circumstances on passion and obfuscation? Because when there are causes naturally producing in a person powerful excitement, he loses his reason and self-control, thereby diminishing the exercise of his willpower. So, makakahinumdum kita, ano, may da mga tao nga nagyayakan nga, nagsirum nakpangitaan, asya nahimo ko adto, nga, crime. I did not bagan nagdulom 'no, nagdulom ang akong pangita 'no. So, that's why I caused injury to another person because the feelings of excitement 'no, is so powerful na umabot ang point nga walay na niya kakontrolan niya kalugaringon. So, as a result, he committed the crime. So, I have an example here 'no. The so Um, this is the case of people versus engay. No, sorry, wari ko kabutang dida. People versus engay. So, what is this case about? So, facts. The accused, as a common law wife, lived with the deceased for 15 years, whose house she helped support. Later, the deceased married another woman. The accused killed him. No, okay. Sorry, wari kabutang. So, ano't istorya hini? So, may adaduduwa nga mag-asawa, but they were not legally married. No, they were common law spouses. So, the accused here is the woman, the common law wife. She has been living with her common law husband for 15 years, and for that 15 years, she supported and helped in establishing the house. But then again, after 15 years of living together, the common law husband decided to marry another woman. So as a result of that act of the common law husband to marry another woman, the accused under under the precepts of passion and obfuscation, she suffered from extreme excitement and anger on the acts of her common law spouse of marrying another woman after supporting him for a long time. It produced such level of excitement and emotions upon her, which compelled her or propelled her to kill the common law spouse. Okay, so may namatay din he. Who died? It was actually the common law spouse. Okay? So what was the decision of the court? Although it was held in a previous case that the causes which produce in the mind loss of reason and self-control and which lessen criminal responsibility are those which originate from lawful sentiments, not those which arise from vicious, unworthy, and immoral. Yet such is not the case here, where the fact that the accused lived for 15 long years as the real wife of the deceased, whose house she helped support, could not but arouse the natural feeling of despair in the woman who saw her life broken and found herself abandoned by the very man whom she considered for so long a time as her husband, and for whom she had made uh so many acts, no? The mitigating circumstance of passion or obfuscation was considered in favor of the wife here, of the common law wife here. So imagine, no, after living for such a long time with the husband, the common law husband, yes, they are not married. They are not married, but under the rules of under our rules, a person also is entitled to protect it is entitled to some level of protection. And here, the act of the common law husband of marrying another woman resulted to such a level of passion and obfuscation on the part of the common law wife here, which actually uh can mitigate, can result to mitigating circumstances. So here the court no um allowed for mitigating circumstances. So here, probably depending on the case filed against here, probably it is murder or homicide. So let's just say murder was filed against the common law wife here. Instead from suffering the penalty of reclusion perpetua, which is the penalty for murder, the imposable penalty will now be what? Reduced by 1 degree. So most probably, she is only going to be penalized for what? Reclusion temporal, no longer reclusion perpetua, because there is a mitigating circumstance of passion and obfuscation in the circumstances surrounding the case. So, passion or obfuscation is a mitigating circumstance because the offender who acts in passion or obfuscation suffers a diminution of his intelligence and intent. Okay, so going back to our characteristics, basic characteristics of a crime, diba? We have intent, intelligence, and freedom. So as I mentioned earlier, if one of them is missing, there is no intent, there is no intelligence. So then certain considerations are taken by the court. It could justify the crime, no, it could mitigate the crime, or it could uh exempt the person committing the crime from criminal liability. So in this case, because there is no loss, karayog singon, there is still intelligence, there is still intent. No, it's still there. It's just that it is reduced. The intelligence of the person is reduced. Diminution. There was no complete deprivation of intelligence and intent. It was diminished. Okay, na-reduce ang iya intelligence and intent. But she is not completely deprived of reason. Unlike that in insane persons, 'di ba? Kasi insane persons are exempt from criminal liability. In her here, she is not exempt from criminal liability because there is still intelligence, there is still intent to kill, but at the end of the day, the intelligence and the intent is reduced. But there is no complete deprivation of intelligence and intent. That's why passion and obfuscation can only warrant mitigating the crime. It does not what exempt. No, it does not exempt or justify the crime. So na-diminish la. Waray mawara ang intelligence. Intelligence and intent is not lost or completely lost in this situation. It's just that it was reduced during the time that the person who committed the crime was what? Under the influence of extreme passion which results to obfuscation. Nagdulom an iya panhunahuna. He could no longer understand what she was doing, or she could no longer control the impulse upon her. But at the end of the day, she knew. No, she still knew. She still knew that she was committing a crime. There was no complete deprivation, no, or there was no insanity. There was no imbecility. It's just that the intelligence and intent are diminished. Okay. Next, paragraph 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. So there are two acts here. Number one, voluntary surrenders to a person in authority or his agents. Now, so voluntary surrender is actually a mitigating circumstance. It can reduce the imposable penalty upon an accused. Number two, voluntary confession of guilt before the court prior to the presentation of evidence for the prosecution. So, if you voluntarily confess your guilt, no, which means that of course the case will now be closed. No, the case will not go to full blown trial, which is beneficial to the court and all the parties, because here the accused has already voluntarily confessed his guilt. So it is taken as a mitigating circumstance. So if there are two, these two are present. So the accused voluntarily surrendered to the police, and during the hearing, the accused voluntary voluntary confess the guilt, then the court can appreciate two mitigating circumstances. So for example, the case was murder, no? Murder is punishable by reclusion perpetua. Instead of being penalized for reclusion perpetua, if the accused voluntarily surrenders and voluntary confesses his guilt, no, during trial, then there will be there will be 2 degrees, or the mitigating circumstances would warrant the reduction of the penalty by 2 degrees. So instead of what being penalized for reclusion perpetua. So going back to our discussion, no, we actually have a table on that. So I will just show you. Okay, here. So normally, without mitigating circumstances, murder would be punished by reclusion perpetua, right? But here, there are two mitigating circumstances. Voluntary surrender, so would warrant reduction of the penalty by 1 degree. So if there is a confession of guilt, no, prior to presentation of evidence, then this would also warrant an additional mitigating circumstance of voluntary confession, which would again reduce the imposable penalty by 1 degree. So these are called degrees of penalty. Now, so in the foregoing case, no, if the accused is, of course, he will be found guilty because he already confessed his guilt. So there's no need to continue to hear, or to continue to present evidence, because it is the accused himself who voluntarily confessed his guilt. So here, definitely, he will be found guilty for murder. But instead of receiving the penalty of reclusion perpetua, because of the two mitigating circumstances, he will only be made to suffer prison mayor. Okay? Which is 6 years plus 1 day to 12 years. So imagine the effect if there are 2 or 3 or 4 mitigating circumstances, because it could go up to arresto minor. No, if there are other mitigating circumstances that can be appreciated. So instead of being penalized for a maximum of 40 years because there were two mitigating circumstances present, then instead nga 40 years and maximum penalty, the maximum penalty will be reduced to 12 years. So that's the effect of mitigating circumstances. If these are proved, then it would result to the reduction of penalties, imposable penalties to the accused. Okay? So, voluntary surrender or voluntary confession. But of course, there are rules pertaining to voluntary surrender. So, we also have to understand that not all types of voluntary surrender can be considered as mitigating circumstances. There are always requisites on that. So we go back to the requisites of a voluntary surrender. So how do we do that? what do we do so that voluntary surrender and voluntary confession of guilt can be considered as a mitigating circumstance? We first go to requisites of voluntary surrender, that the offender had not been actually arrested. So of course, if the offender has already been arrested, no, he cannot trace the mitigating circumstance of voluntary surrender, because if he was actually arrested and by the by persons in authority or agents of person in authority, then there was no voluntary surrender. No? Number two, that the offender surrendered himself to a person in authority or to the latter's agent, and that the surrender was voluntary. He was not compelled. So kung ginserbihan niya warrant, tapos ginaresto hiya mismo, diri ito hiya voluntary surrender. Bisan pa yan nagakan, sige, na voluntary surrender na ako. Pero kay nagsiserve na kasi yung warrant. So you don't wait for the warrant to be served. You go immediately to the person in authority, such as the mayor, no, of the city or the municipality, or you go to the police. You don't wait for the warrant to be issued for your name, no, because if there's already a warrant, then there's going to be an arrest. And it will not tantamount to voluntary surrender if you are served with a warrant and then you get arrested. So there's no voluntary surrender here. So you don't wait for the warrant. Before the warrant is issued, you immediately go to the person in authority or his agents, and yun, you voluntary surrender. So for example, 'di ba? For example, ha mga nakakaligis, no, a person who hits who can be held liable for reckless imprudence resulting to homicide. So it mga nakakaligis, what they do is they surrender. Probably not mismo dito sa vicinity where the accident happened, because sometimes it mga tao nga dahil palibot medyo anehera, medyo aggressive hira, nahadlok siguro kakastiguhon. So, iba nga mga drivers nga nakakaligis, natakas anay hira. No, natakas hira. They remove themselves from the scene of the crime, but then they will voluntarily surrender. Iba ha, next municipality. So that is considered as a voluntary surrender in the part of the accused. And yun, then mitigating circumstances, no, can be considered is for the offense. So example, immediately after the shooting, the accused, having all the opportunity to escape, did not do so, but instead called up the police department. When the policemen went to the scene of the crime to investigate, he voluntarily approached them and, without revealing his identity, told them that he would help in connection with the case as he knew the suspect and the latter's motive. When brought to the police station immediately thereafter as a possible witness, he confided to the investigators that he was voluntarily surrendering and also surrendering the fatal gun used in the shooting of the victim. These acts of the accused were held strongly indicative. So it indicates this his intent or desire to surrender voluntarily to the authorities. So, kumadto umupod hiya, hapresinto, and there he confessed, no, or he told the police investigators that he was voluntarily surrendering, and he, to the extent that he actually also surrendered the weapon used for the crime, no. So that's an example of a voluntary surrender. But take note, no, not all surrenders are considered mitigating circumstances. The three requisites must be present. The offender had not been actually arrested, because if he is already arrested, then no, there's no voluntary surrender. That the offender surrendered himself to a person in authority or to the latter's agent. So you cannot surrender yourself just to anyone. You can either surrender to a person in authority, for example, a mayor, no, a mayor of a city or a municipality, or to the latter's agents, so police officers, and that the surrender should be voluntary. Now let's go to requisites of a voluntary plea of guilty, no? Or confession of guilty. In order that the plea of guilty may be mitigating, the three requisites must be present. So take note, not all pleas of guilty are considered mitigating. So there are also requisites. Number one, that the offender spontaneously confessed his guilt. Okay, so spontaneously, waray hiya, gin-rehearse, no? So waray hiya perita, it is of his own accord that he spontaneously confessed his guilt. Number two, that the confession of guilt was made in open court, that is before the competent court that that is to try the case. Okay? So it is made in open court in the court where the hearing for the case is being conducted. Not just in any court ha, the court handling the hearing for the case. No? And number three, that the confession of guilt was made prior to the presentation of evidence for the prosecution. So the confession here must be made before the prosecution offers or begins to what? Present its evidence against the accused. No? So before the presentation of evidence, the confession must be what? Must be must be made, because if it's after the presentation and there's already established that there's guilt beyond reasonable doubt, there's already sufficient evidence to that would tantamount to guilt beyond reasonable doubt, then it only means that the confession of guilt is no longer necessary because the prosecution was already able to establish guilt of the person. So take note of that. No, not all types of confession of guilt is also considered as mitigating circumstances. It should be made prior to presentation of evidence. It should be made prior to the declaration of the court that he is guilty beyond reasonable doubt. Because if there's already a declaration of the court that he is guilty beyond reasonable doubt, then there is no need to confess anymore. No, so that's why. No, example, charged with double murder, the accused moved the court to permit him to withdraw his former plea of not guilty to be substituted with that of guilty to the lesser crime of double homicide. The prosecution moved to amend the information so as to change the crime from double murder to double homicide. Both motions were granted by the held. The plea of guilty to the lesser offense charged in the amended is mitigating. No? So, yeah, actually, the accused can actually plead guilty to a lesser offense, such as, for example, kung murder in case, he or she can plead guilty to homicide. Kaya di ba, homicide, it's a lesser offense. So, mas hamubuan So, homicide is punishable by reclusion temporal, and there's one mitigating circumstance of plea of guilty, then, again, it will go to arresto mayor. Okay? So, yun. However, when the accused is charged with a grave offense, the court should take his testimony in spite of his plea of guilty. The trial court should determine whether the accused really and truly comprehended the meaning, full significance, and consequences of his plea, and that the same was voluntarily and intelligently entered given by the accused. So, even if the accused has already voluntarily confessed his guilt, the court will still what? Try to take his testimony, because the court has to determine, especially if the case involves a grave offense such as murder, homicide, rape, because take note of the gravity of the penalties that a person can receive. No, kay murder, if a person pleads guilty of murder, even if it is reduced by 1 degree, kwan lagi ito, reclusion temporal, di ba? That's still 20 years plus 1 day to, 12 years plus 1 day to 20 years. So, the court must determine whether the accused pleaded guilty voluntarily and he knows the repercussions of such pleading, because he should be apprised that if he pleads guilty to homicide, he is still going to be imprisoned. No, he will be meted with the penalty of reclusion temporal. But if the mitigating circumstance of voluntary plea of guilty is taken, of course, it will downgrade the penalty to by 1 degree to arresto mayor, which is now 60 years up to plus 1 day to 12 years. Okay. So that this is now paragraph 9, that the offender is dumb. Dumb nga ni diri ka sigmon bulok, no ha? Dumb, is deaf and dumb. Sorry, waray kabutangan deaf. Wait lang. Deaf and dumb, okay? Blind or otherwise suffering from physical defects which thus restricts his means of defense or communication with his fellow beings. So, when we say deaf, bungol, dumb, di rin nakakayakan, no? Blind, of course, buta, otherwise suffering from physical defect. In a criminal case charging robbery in an uninhabited house, the accused is deaf and dumb. He is entitled to the mitigating circumstance of being deaf and dumb under Article 13. So kung bungol or ngula ang tabo nga naghimo hito nga crime, then that is taken as a mitigating circumstance. So does this paragraph apply when the deaf, mute, or the blind is educated? Of course, no. This paragraph does not distinguish between educated and uneducated deaf, mute, or blind person. The code considers them as being on equal footing. Okay? So, 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without however depriving him of consciousness of his acts. So here there's a problem, mental problem or physical illness, but then the worker the worker the accused is not completely deprived of reason. No, not completely. It only diminishes his consciousness. That the illness of the offender must diminish the exercise of his willpower, that such illness should not deprive the offender of consciousness of his acts. So he still understand the gravity of his acts. No, it's not in this case the accused is not completely insane or completely an imbecile who is completely deprived of freedom and intelligence in the commission of his crime. In here, the person is just suffering from an illness which diminishes his exercise of his willpower. But nonetheless, he can still fully comprehend or is conscious of his acts. Okay, he can still fully comprehend his acts. Okay. So example, the evidence of accused appellant shows that while there was some impairment of his mental faculties, since he was shown to suffer from the chronic mental disease called disorder of or psychosis, such impairment was not so complete to deprive him of his intelligence or the consciousness of his acts. The schizoaffective disorder or psychosis of accused appellant may be classified as an illness which diminishes the exercise of his willpower but without depriving him of his consciousness of his acts. He may thus be credited with this mitigating circumstance but will not exempt him from criminal liability. So take note, insane and imbecile persons are exempt from criminal liability because they are completely deprived of intelligence and freedom of will in the commission of the crime. In here, there is no complete deprivation of freedom and intelligence as to the commission of the crime. It's just that an iyang mental capacity is reduced. Okay? So there is just a reduction, no, or there is just a diminishing of the exercise of the willpower. But at the end of the day, the person who committed the crime in here, it's just a mitigating circumstance because there was no complete deprivation of freedom and intelligence. There was only a diminution or it only diminished. The mental illness is not to a severe level as that of an imbecile or an insane person. No, there is a mental illness, there is an illness, but it does not completely deprive of the accused of his what? Of his will. And he actually has consciousness in the commission of the crime. The circumstance in paragraph 9 of Article 13 is mitigating because there is a diminution of intelligence of the accused. There was no complete deprivation of freedom and intelligence. The person who committed the crime in here, it's just a mitigating circumstance because there was no complete deprivation of freedom and intelligence. The circumstances in paragraph 9 of Article 13 is mitigating because there is a diminution of intelligence of and intent. If there, so that's the difference. There's only diminution. There is no complete deprivation. If there is complete deprivation of intelligence and intent, then it actually what exempts the accused from criminal liability. But if there's only diminution or a reduction of intelligence and intent, then it's only a mitigating circumstance. Okay, so I hope you understand that. Number 10, paragraph 10, and finally, any other circumstance of a similar nature and analogous to those above mentioned. So here, the law actually provides for such other circumstances not enumerated, no? So even if it's not completely under paragraphs 1 to 9, the law is actually inclusive, no? So it warrants for such other circumstances, it allows for such other circumstances not already listed to still be considered as mitigating circumstances, so long as they are of similar nature or analogous to those already mentioned. So may na nakita nakalista ano nga mitigating circumstances. But even if the circumstance raised is not included in the list already defined under paragraphs 1 to 9. In paragraph 10, these circumstances can still be considered so long that they are of the same nature or analogous or similar to those already listed. For example, a person who killed his debtor who had tried to escape and refused to pay his debt is entitled to mitigating circumstance similar to passion and obfuscation. Kanina 'di ba, may ada ano, nag-asawa utro 'di ba, ang passion of obfuscation. Iba ang gin-asawa ngayon, iba ang gipakaslan to the extent that the former common law wife suffered from such severe passion and obfuscation of the mind that resulted her to killing her common law husband. Adiliwas, may dautang. So, a debtor, a debtor tried to escape. So, the creditor here, the person whom the debtor owes money, killed him because of such level of anger kay waray babayari an iya utang. But then again, the debt or the passion or obfuscation is similar to that of those persons who suffered because nga no who suffered because nagduluman ira pangitaon tungodan ira kaisog or kapungot, no? Number 2, on the other hand, voluntary restitution of the property stolen by the accused or immediately reimbursing the amount malversed is a mitigating circumstance as analogous to voluntary surrender. So for example, may ada nangawat. So after niya mangawat, ginbalik niya kinawat, it can be considered as a mitigating circumstance because it would be similar to a voluntary surrender. So it it pagbalik it butang nga kinawat will not exempt the accused from criminal liability. The restitution, it pagbalik han kinawat, is only a mitigating circumstance. Now, it only reduces the penalty that can be imposed, but at the end of the day, that person can still be held liable for the crime and he can suffer penalties of imprisonment, fine, or other other penalties imposable. Number 3, extreme poverty may mitigate a crime against property such as theft but not a crime of violence such as murder. So for example, a person, 'di ba, if you can still remember, ang lagas nga nangawat han mangga nga iyaliwat gin baligya, 'di ba? There was really a case against him because there was taking a personal property belonging to another. Very clear manggod nga ang punuhan mangga um was already inside an enclosure and ditohan property hantag iya, no? The thing is, under our laws, the taking of theft, no theft. Theft is when a person takes the property of another person without force or intimidation with intent to gain. So number 1, he took the mangoes no belonging to the to the to the person who is the owner of the property. Kaya take note, under our civil code, itong trees, no, trees that are attached to a land, it owner hiton land hito, itag-iya hito nga tree. Bisan hino pa ito dida it nagtanom. Ownership of a tree, no, attached to a land belongs to the person who owns the land. So ato yan natabo ang mango tree nakasulod hiya, di ba, naka-fence out hiya. Yun nga lang ang ibang nga branches nagawas didtohan fence. So ang ginbuhat hadto nga lagas ginpanguhan niya ang mga mangga. But at the end of the day, it was established that the property, the land to which the mango tree was attached belonged to another person. So, sulod hiya theft, di ba? Taking a personal property. Okay lang sana kung nagkahudlog lang ito nga mga bunga. Dito han mangga. Okay lang. No? Kasi if mahulog na kasi it bunga haing mo tuna, okay na ito. No? Bagan, bisan hinon na ito, kung diin yan nahulog, ang tag-ihan to na kung diin nahulog ang bunga han mangga, can actually own that mangoes. But what happened is, purposely niragin kuha ang mga mangga from the tree, waray magkahudlog, no? So basically, those fruits of the tree still belonged to the person who owned the land to which the tree was attached. So, yun, taking a property with intent to gain, kay iya nga naging pambaligya, 'di ba? So, in as much nga naluluoy kita, no, we still have laws under the Philippines, and the law may be harsh, but it is the law. So, if a crime is defined under the criminal laws, no, so 'di ba, during when we were studying the basic principles of criminal law, the law may be harsh, but it is the law. And if an act or omission is already defined under criminal laws, then the court is without other recourse but to enforce such law. So it may be harsh, but it is the law. Jura lex sed lex. So ginkasuhan hiya hin theft. Ani mga tao mayakan na waray naman la kaluoy ano. But of course, yes, there are certain humanitarian considerations on that. That's why extreme poverty, old age, 'di ba, beyond 70 years old, these are considered as mitigating circumstances. So adto hiya kay theft man la adto, diri man adto robbery, so hamubol adto induro it iya penalty, he can still be held liable, but then there are mitigating circumstances surrounding the event or the theft. So pwede niya i-grace and mitigating circumstance of extreme poverty, of old age, 'di ba? So, and voluntary surrender gihapon. So, pwede adto. May mga mitigating circumstances. And maabot na lang ito nga, there will be no penalty left to enforce. No? Kay mas umubos pa nga niya at aresto mayor, de karek signon fine na la ipapabaydan na iya. Diri na hiya priprisohon even if he is found guilty for theft, because honestly, the requisites for theft were there. No, number one, there was taking a property for with intent to gain, but then the taking of property was without force or intimidation. So that's why it was just theft. So ito, these types of considerations are being understood by our courts and being applied by our courts when it tries to what? When it tries to adjudge certain cases. Okay? So I hope you will not forget our justifying, exempting, and mitigating circumstances, because on Wednesday we will be meeting. No, we will meet, and we will be having a review on the three circumstances affecting criminal liability before we go to aggravating circumstances. So definitely on Wednesday we will meet on Zoom. No, it's just that today, Monday, I cannot meet with you because I have a very important activity to attend to. But on Wednesday we will meet. We will have a short review on the justifying, exempting, and mitigating circumstances before we move on to aggravating circumstances by Friday. So again, we will meet on Friday as well for the aggravating circumstances. I would want to meet all of you because we will be having your exams once again this month. No? So I want you all to be ready to answer I think we are pre-final na ata, no? Pre-final exam on um before the end of this month. So, yun, we have to review first the three uh justifying, exempting, and mitigating circumstances. So, if you have any questions, kindly take note of them and immediately raise them during our class on Wednesday. So we will definitely, most definitely, we will meet on Wednesday. Okay, on Zoom. I will prepare the Zoom link very soon, and I hope that you will all be present on that day. We will have a recitation, and at the same time, we will have a short review of all the things that we have already discussed. And soon we will moving on to aggravating circumstances. So soon also we will be discussing alternative circumstances. So these are the basic concepts that on the circumstances affecting criminal liability. So anyway, thank you so much for spending your time with me. I think you are expecting to have a quiz for today. So I will not give you a quiz for today, but make sure to be present on Wednesday during our Zoom class because we will be having a recitation. So I will just be sending a form link for our attendance. So fill out the attendance so that I can note that you are present on Monday. But Wednesday, Friday, we will meet definitely on Zoom. Okay? So good afternoon, everyone. I hope you learned something from our discussion today. I'll just see you on Wednesday and Thursday. Keep safe always, stay healthy, and God bless. Bye for now.